Welcome back to the Supreme Court of the United Kingdom, where today we're hearing the appeal in the state of Libya against General Dynamics United Kingdom Limited. At present, we're hearing the submissions of Mr. Toledano, Queen's Counsel, on behalf of the respondent. Mr. Toledano.
Thank you, my lord. Can I just answer, if I may, straight away, the question put to me before the break by my Lady Arden in relation to the factual position and any request for service. And the answer to that is that prior to the hearing before Mr. Justice Tier and then the hearing before Lord Justice Males, we had not specifically requested that service be affected or formally requested that service be affected. And that was because we'd been told about the problems that I've identified that are reflected in the judgments of the courts below, but both originally by the FPS, which is the Foreign Process Service of the Queen's Bench Division, and subsequently by the Foreign and Commonwealth Office when we had discussions with them. However, after we got Lord Justice Males's judgment in January 2019, which is, as the court knows, concluded against us and overturned the decision of Mr. Justice Tier, we then took the view that we would have to make a formal request for service in the circumstances. And so we did that on or about the 22nd of February 2019, and we wrote to the solicitors acting in these proceedings for Libya, Curtis Mallet, and we told them, and I'm reading now from the letter, today, this is the 22nd of February 2019, our client is filing with the Foreign Process section of the court a request for service of documents on a state pursuant to CPR 6.44, requesting service of the following documents, and then it set out all the documents. So a formal request for service was then made in February 2019, and it is, in a sense, it goes without saying that we are here dealing with this matter today because service has clearly not been affected via that route. That's nearly 2 years ago now because, as I say, it was February 2019. I hope that answers my lady's question.
Well, Mr. Toledano, was there in evidence any further correspondence with the Foreign and Commonwealth Office in relation to the formal request once made?
My lord, I don't believe there was, and that's because, as I say, this was only made after we got judgment from Lord Justice Males. Then the matter went to the Court of Appeal and was addressed in the Court of Appeal on the basis of the material before the court, which was, I think, the same as the material that had been before Lord Justice Males. In other words,
we have no information in relation to the attitude of the Foreign Commonwealth and Development Office after the formal request was made.
There's no evidence of that, my lord. That's true. Obviously, if the court wanted to know precisely what communications there have been since then, we could obviously put that before the court. But that is not in evidence for the reason I've given. What is clear, and what I can tell the court, is service has not been affected by that channel, and it's nearly 2 years now since that formal request.
Thank you very much. And would you say that we have to consider the position at the date which it was before Mr. Justice Tier?
Well, the answer to that, which was a point that was debated below, is that we did submit below that the relevant date is the date when it's looked at. The relevant date for the purposes of exceptional circumstances is the date that the court was looking at it, Mr. Justice Tier was looking at it. But the authorities do suggest that the court can take into account subsequent events insofar as they shed light on the position as it stood then. So I would submit that this court can take into account the fact that there's been 2 years, nearly 2 years, has gone by without service being affected pursuant to that formal request. That can be taken into account by this court because it sheds light, and indeed we say absolutely reinforces the conclusion that was reached both by Mr. Justice Tier, then by Lord Justice Males, who said he couldn't think of a more exceptional case, and then upheld by the Court of Appeal. So we would say this court can take it into account.
Thank you.
So, my lords and my lady, I move on with my submissions then. The conclusion, and these are the overarching points I said I wanted to make, the conclusion that Section 12.1 does not apply to all proceedings or to all documents is one that fits well with the primary purpose of the 1978 Act. The Act gave effect to the restrictive theory of state immunity. This had already been recognised prior to the Act by the Privy Council and the Philippine Admiral in 1975 and by the Court of Appeal in the famous Trentex case in 1977, then approved by the House of Lords in the Primero Congreso del Partido in 1982. As Lord Sumption made clear in Benkabush, this was the only theory of state immunity that has ever secured a consensus internationally, and therefore it is the very essence of state immunity. And the restrictive theory is concerned with the nature of the acts done by the state in question and whether they're sovereign in character or private and commercial. Now, the procedure to be adopted when impleading foreign states is something we say is separate and distinct, and that is clear from the structure of the 1978 Act itself, which contains the restrictive theory in sections 1 to 11 through the drafting technique of an immunity with exceptions. It then contains section 12 under the heading procedure. Section 12 does not form part of the delineation of state immunity itself. We submit as a matter of logic and principle, procedure should be something for the forum state. It's not about the substantive rights of states, but simply about how states are formally notified of claims brought against them in domestic courts. Yet, Libya seeks to elevate the procedure to the same status as the restrictive theory by saying that it too is part of customary and international law. And in order to succeed on this appeal, it goes so far as to say there is a rule of customary international law that requires service through diplomatic channels, even in exceptional cases. Now, service by the diplomatic channel necessarily does require the participation or consent of the state in question. There has to be a functioning diplomatic channel, and the state has to be willing to accept communications through it. So on Libya's case, both the 1978 Act and customary international law adopt the restrictive theory on the one hand, but on the other hand, insist inflexibly on a single form of service in every case. And we submit that that makes no sense at all. Libya's inflexible service requirement clashes with the restrictive theory itself. Where the acts of state are private in character, the state has no immunity and may be impleaded in domestic courts without its consent. We submit that's not so on Libya's case, because the state can decide not to consent to the proceedings by defeating the only permitted method of service, and it thereby helps itself to an immunity that it does not have under the restrictive theory. And we say that cannot be correct. We have described in our written case several recent examples of cases where states have essentially blocked service by refusing to accept documents via the diplomatic channel, either as a general policy or in the particular proceedings. And they are summarized in footnote 1 of our written case, and they involve Iran, Syria, and Eritrea. And even in cases where the state has not necessarily set out to defeat service, but there is no diplomatic channel at all, or where it would be too dangerous to serve by that method, as in the present case, the position is the same, because unless there is some way of serving proceedings or dispensing with the need to serve, then it will not be possible to pursue a claim against the state, even though it does not have immunity. And we say the tension is particularly acute in the context of applications to enforce arbitral awards against states, because in such cases there is no immunity because Section 9 of the Act applies. And there should therefore be no question of the state having the power to decide whether or not it will consent to the service of enforcement proceedings against it. Now, the assumption underpinning Section 12.1 is that the method of service there referred to...
Forgive me, before you move on, you refer to Section 12, to Section 9. Section 9, of course, is, as my ladies pointed out this morning, is concerned with adjudicative jurisdiction in matters relating to arbitration, not to enforcement at all.
My lord, that's a very important point, if I may say, and I'm coming to the Court of Appeal decision on this very point, but an application of the kind made by General Dynamics in this case under Section 101 of the Arbitration Act for recognition of the award and entry of the award as a judgment of the court is considered as the final step of the adjudicative process of the court. It's not considered as part of the subsequent enforcement or execution process. And that's terribly important. And the Court of Appeal has held in terms that Section 9 and the exception to immunity contained in Section 9 does extend to applications of the kind that your lordships and your ladyship are dealing with in this very case. So applications for enforcement of an arbitral award. And that's because that sort of application is the final step in the process of making an arbitral award effective. So it is part and parcel of that adjudicative process, and it is something for which there is no state immunity under the restrictive theory and under Section 9 of the Act. And I am going to, if I have time, I will take the court to the Svenska case, which is the relevant Court of Appeal case, because not only do they say that Section 9 is clear on its language, the Court of Appeal actually refers to the Hansard debates, where it's quite clear from the materials that the court took into account that Section 9 was intended to extend to applications of this sort.
Right.
Can I move on then? The assumption underpinning Section 12.1 is the method of service there referred to is ordinarily one that works and that states accept. By and large, that is obviously the case. We submit, though, in cases where the assumption doesn't hold good, where the circumstances are exceptional, the answer must be one that accords with the restrictive theory and that does not allow states to opt out of proceedings against them. So although Libya prays in aid customary international law in support of its case, in our submission, giving effect to the restrictive theory of state immunity leads to the conclusion that its case must be wrong. Can I then turn from those overarching points to our primary case, if I may, on the construction of Section 12.1, which was the case that we succeeded on in the Court of Appeal. Now, the first point I'd make is that the language used in Section 12, as the court has already seen, was different to the language which had been used in Article 16 of the European Convention. Article 16 referred to the document by which the proceedings are instituted. Section 12.1 introduced the additional condition that it only applied to such documents if they were also ones which are required to be served. And in that and many other respects, the statute does pointedly depart from the terms of the European Convention. And indeed, the commentators recognise, we've set this out in our written case, that by the time the Act was passed, it was a more radical restatement of the law and wasn't designed simply to give effect to the Convention. That's footnote 21 of our written case. Another example of the difference between the two, I think there was one this morning on my Lord Stevens in relation to counterclaims, but another example of the difference between the two is that Section 12.6 of the Act permits service by a method agreed with the state, whereas there is nothing to this effect in the European Convention. That's a very important point of starting point. Now, in order to ascertain whether the conditions in Section 12.1 are satisfied, it is, we submit, necessary to consult the procedural rules now to be found in the CPR. Having chosen a test of required to be served for instituting proceedings without specifying when a document is required to be served or when it counts as a document for instituting proceedings, Parliament must have intended the answer to those questions to be found elsewhere. And it is the domestic rules of civil procedure which indicate whether the document is required to be served and whether it is for instituting proceedings. And as I said before the break, the whole focus of Section 12 is on domestic procedure. The rules of court are expressly referred to in subsections 2, 5 and 7 of Section 12. There are also terms such as writ, entry of appearance and default of appearance, which are terms of art with an established meaning in English procedure. Parliament must have intended them to have their established procedural meaning. So Libya are, we submit, wrong to suggest in their written case that the appeal doesn't involve a prosaic journey through certain provisions of the CPR. Reference to the CPR, prosaic or otherwise, is in fact required by Section 12. Can I invite at this stage the court's attention back to Section 12, please? In the primary authorities bundle, at page, in mine it's at page 13, it might be 14 in the court's bundle. Now, that procedure set out in Section 12 accords with the usual procedure for claims involving familiar steps. First of all, a writ, now referred to as a claim form, which is served, and that is subsection 1. Secondly, a requirement to enter an appearance, now referred to as acknowledging service, that is subsections 2 and 3. Thirdly, a judgment in default of appearance or acknowledgement, which is subsection 4. And fourthly, service of a default judgment and an opportunity to set it aside, which is subsection 5. Now, where you have an ex parte procedure of the type...
Forgive me, before you move on, am I right in thinking we're not concerned with any of those?
That's exactly right, my lord. We are not concerned with with any of those, and that's because that scheme simply does not apply to the ex parte procedure for enforcement of arbitral awards. You simply don't have any of those 4 steps, because what you have instead is an alternative procedure, which in my submission consists of entirely different steps. And those are to be found in 62.18 of the CPR, which you should have at page 29 of your authorities bundle. I'm adding 1. If I'm wrong to add 1, please do let me know. So at page 29, you have 62.18. And if you, my Lord Briggs.
You are wrong to add 1.
Ah, okay. I'll subtract 1 then.
I think it'll save time in the long run if you always subtract 1. Thank you.
So at page 28, 62.18 then. Now what you have there are first of all, an application to enforce the award, which is made without notice in an arbitration claim form. That is 62.18 paragraph 1. The arbitration claim form institutes the proceedings, as with all other claim forms, but it's not required to be served unless under 62.18(2) and 3, the court directs that it should be, which of course it did not in the present case. The court then grants an order which has to be served, and you see that in 62.18 sub 7 and sub 8. And in this case, the order was made about a month after the proceedings had been instituted. The order we submit had nothing to do with the institution of proceedings. In fact, the order involved the court actually granting the substantive relief sought in the proceedings. The proceedings sought the very relief that was granted in that order. That was the relief being granted. And that was the permission to enforce the award. And then under 62.189, the person against whom the order is made has a period to apply to set it aside. Now, we submit that machinery simply cannot be squeezed into the wording of the statute. The Court of Appeal was right to conclude there is no document falling within Section 12. The arbitration claim form instituted the proceedings but was not required to be served, falls outside of Section 12. That point was previously decided in a case called Gold Reserve, which we refer to in paragraph 61 of our written case at page 68, and Libya has never challenged the correctness of that authority. So Libya focuses its attention instead on the order granted ex parte, says that this is the document which falls within section 12.1, and that was the conclusion of Lord Justice Mayles as well. But there are, we submit, numerous problems with Libya's case in relation to the enforcement order and generally in relation to the wording of section 12. And I'd ask you, if I may, to go back to section 12 at page 13, so that I can just identify what we say are the difficulties that arise on Libya's case in this context. The first difficulty faced by Libya is that it has to say that the order granted ex parte is a document required to be served for instituting proceedings within subsection 1. Yet it's not a document that institutes proceedings at all. The proceedings were instituted by the issue of an arbitration claim form some weeks earlier. The second difficulty is that Libya is forced to say that applying to set aside the ex parte order is the entry of appearance. Now, at one point this morning, my learned friend seemed to say that applying to set aside the ex parte order would be an entry of appearance under section 12.2. Then in answer to a question, I think he backtracked on that and suggested that maybe it wasn't an entry of appearance at all. Quite clearly, it's not the entry of an appearance. It's something quite different. If you look at subsection 4, you'll find the meaning of entry of appearance, because in default of an entry of appearance, there can then be a default judgment. And you see that in subsection 4. But if no application is made to set aside the ex parte order, there is no default. And it doesn't lead to the possibility of a default judgment, nor is a default judgment needed because the claimant already has the ex parte order. So the application to set aside the ex parte order cannot be an entry of appearance. The third problem faced by Libya is that it must accept that where the ex parte procedure is used, there is no default judgment and there is no setting aside of default judgment. In other words, Libya would have to accept that subsections 4 and 5 do not have any content or application at all. So on their case, subsections 1 and 2 apply and are cooperative provisions, or that's certainly how they put it in their written case at paragraph 5.12 at page 34. They say 1 and 2 apply and are cooperative, but they'd have to accept that subsection 4, which by its express wording is also cooperative with 1 and 2, has no application at all.
Yeah.
So that simply doesn't work. In fact, none of that works. And the reason we submit is that the ex parte procedure falls outside of section 12 altogether, and the Court of Appeal was correct to conclude that that was so. Now, Lord Justice Mayles at first instance accepted that the proceedings were instituted by the issue of the arbitration claim form, and that was a document which was not required to be served. That was in his judgment.
I wonder if you could go a little slower, because this is important and detailed stuff, and we need to take a note.
Of course, my lord. I do apologise if I was taking it too fast.
Not at all. But you were saying Lord Justice Mayles accepted.
Yes. So Lord Justice Mayles
accepted that the proceedings were initiated within the meaning of the rules at the time the application was made.
But yes, he said they were instituted by the issue of the arbitration claim form, and that was a document which was not required to be served. He accepted that. That was in his judgment at paragraph 37. He also agreed that under the CPR, the ex parte order was not a document for instituting proceedings. But so you would have thought, pausing there, that based on those conclusions, he would find in our favour. But he went on to say that was not the perspective, as he put it, from which Section 12 should be viewed. And with respect, we say that's wrong. There is no perspective other than an application of the court rules, as the Court of Appeal correctly concluded in paragraph 30 of its judgment. Now, the other perspective that Lord Justice Mayles had in mind was what he perceived to be Section 12's insistence on there always being some document required to be served for instituting proceedings against a state. But we submit Parliament plainly didn't intend to require diplomatic service in all cases in which a state is impleaded. Now, that is clear, not just from the terms in which Section 12.1 is drafted, as I've been submitting, but also from the limitations on the scope of Section 12 that we have referred to in our written case at paragraph 50. And if I could just draw your attention to that, it's at page 60 of the key documents bundle. So it's what we've set out in paragraph 50 are a number of instances when the statute does not require diplomatic service, even though a state will be impleaded. The first example we give is actions in rem.
Well, how could that possibly be done by the Foreign Office?
Well, my lord,
if you're arresting a vessel, there's only one way to do it.
Well, that may well be right, and I don't suggest. Well, in fact, I think there are now a few different ways you can do it. But your lordship, I see your lordship's point. What I would say, however, is that it does show that you don't always have to do diplomatic service. I mean, the point is that actions in rem are actually a form of direct impleader. Lord Sumption made that point in the Belhage case at paragraph 187. In substance, they are proceedings against the state, and indeed, Lord Wilberforce in the Primero Congreso case made the point that many jurisdictions don't even recognise the distinction between in personam actions and in rem actions. So you do have an action here that is against the state in substance, and yet Parliament saw fit to exclude them. And what that shows is diplomatic service is not always required, and saying that it's always required when a state is impleaded cannot be the correct starting point. And that's only one of the limitations that we've identified in paragraph 50. In paragraph
before we move on, if you're arresting a vessel, you don't have to have initiating process, do you? In the form of a writ or an.
Well, I think you. My understanding is
proceedings.
My understanding is you do have an initiating process, but you can sometimes affix it to the vessel in question. But you do have an initiating process.
But it's by reference to the vessel, it doesn't require service on an individual defendant.
That's right. That's my understanding. I mean, I'd have to check that, but that's my understanding, my lord. So that's and I take your lordship's point but nonetheless, the point I'm making is that it is nonetheless a form of direct impleader against the state, and it doesn't involve diplomatic service at all. I mean, that you could have had you could have had a requirement that in addition to affixing something against the vessel, you have to serve diplomatically against the state in question, but that isn't something that's provided for, and in rem actions are carved out. And we give a second example in paragraph 50b, which are indirect impleader actions, where there's an action against state property or against separate state or against separate entities, which are themselves defined in the Act. So the state has an interest in the property or has an interest in the action against the separate entity and is indirectly impleaded, yet service on the state under section 12 is not required. We also refer to claims which fall outside of the SIA altogether, and your lordships and your ladyship will know those are dealt with by section 16 of the Act, which are governed by the common law. Again, no requirement for diplomatic service in those cases because they fall completely outside of the SIA. And in 50 sub D, we refer to claims against diplomatic agents. And so what we say is that the impact of these limitations on section 12 is significant, and it shows you that Lord Justice Miles's starting point, that you have to always have a document served through the diplomatic channel, can't be the correct starting point. And we do say that the wider procedural context of the 1978 Act reinforces those limitations. And the starting point there on the context is that as at the time of the 1978 Act, there were procedures already in place by which a defendant would become subject to the court's jurisdiction without there being a requirement for service on it of the document by which proceedings were instituted. And Parliament must be taken to have been aware of such procedures. And there are two important areas that we rely on. The first is the enforcement of foreign judgments, and the other is the enforcement of foreign arbitral awards. And as you've seen from our written case, from at least 1966 onwards, applications to register foreign judgments under the 1920 and 1933 Acts could be made ex parte. And as at 1978, that procedure in fact applied to many more territories than we had indicated in paragraph 53b of our written case. At page 63 of the key documents bundle, paragraph 53b, we thought that this procedure only applied to judgments from 15 countries. In fact, as at 1978, the 1920 Act extended to 56 territories, and I apologise for not having this in writing, but we only discovered this very recently. The 1920 Act extended to 56 territories, and that was set out in a consolidated form shortly after the SIA in the Reciprocal Enforcement of Judgments Administration of Justice Act 1920, Part 2, Consolidation Order 1984, which is Statutory Instrument 1984 129, and the 1933 Act extended to a further 14 countries, which are the ones identified in 53B, with the exception of Canada, which wasn't added until later in 1987. So from 1966, in all judgments from all of those different territories could be registered under those acts, the 1920 and 1933 acts, in this way. So it's a significant matter that was already in place in 1978. And to add to that,
forgive me, Mr. Toledano, did that procedure for enforcement of foreign judgment, registering under the different acts, did that involve serving an order at any stage on a defendant state?
I think we've set that out in writing. The answer is that you didn't have to serve the order. What you had to do eventually was serve notice that the order had been registered in the register of judgments.
Right. So it may be analogous to the present situation then.
It's analogous to the present situation, exactly. Although you didn't actually have to serve even the order, you just had to serve notice of registration in the register of judgments. Now, it's also the case that from 1966, the same procedure applied to the registration of foreign arbitral awards, which met the test set out in RSC Order 73, Rule 8. And I would just like to draw the court's attention to that. That is in the Primary Authorities bundle at page 37. So this was already in place in 1978 as well, Order 73, Rule 8. You can see that it applies to where three conditions are met. First of all, you have to have an award that is made in a territory to which the 1933 Act extended. Second of all, it has to be a territory to which the 1920 Act had previously been extended. And thirdly, the award had become enforceable in the same manner as a judgment in the place where it was made. So that applied to that category of arbitration awards. Now, when we submitted our written case, we had thought that all of the countries we identified in 53B of our written case met that test. On further analysis, it appears that those territories didn't meet the second of those three conditions as at 1978. And it may be, from what we've been able to ascertain, that no country met all three conditions as at that date. But that said, it was clearly contemplated that some countries would or might in the future meet this test by having the 1933 Act extended to them, such that Order 73, Rule 8 would then have practical application. And certainly it appears that at least two groups of territories are now covered by this provision, a number of Australian states and a number of Canadian territories. So that was the position in relation to enforcement of foreign judgments and this category of arbitration awards. The next important moment in the contextual chronology was in 1975, when the Arbitration Act 1975 was passed in order to give effect to the New York Convention of 1958, which was then ratified by the United Kingdom later in 1975. And in order to facilitate ratification, the UK had to ensure that it had appropriate mechanisms for the recognition and enforcement of awards covered by the convention. And it did that in two steps. First of all, Section 3.1 of the Arbitration Act 1975, which we don't need to go to, but which is at page 1285 of the authorities, provided that New York Convention awards could be enforced in one of two ways, either by an action on the award or by the procedure set out in Section 26 of the 1950 Arbitration Act, which contained the statutory process for obtaining leave to enforce arbitral awards. So that was the first step. The second step, on the 1st of September 1978, the RSC were amended. by the insertion of a new Order 73 Rule 10, and that introduced the ex parte procedure now found in CPR 62.18 for obtaining leave to enforce arbitral awards, both domestic and those covered by the New York Convention. And I'll come back to the terms of the new Order 73 Rule 10 in a moment. Can I just deal now with the precise timing of the introduction of Order 73 Rule 10? We've set it out in footnote 32 of our written case, but just so that you understand the position, the Act...
Sorry, which footnote? I'm sorry, you're going rather fast, Mr. Toledano.
I'm so sorry, my lord.
Which footnote?
It's 32. It's at page 63 of the key documents bundle.
Thank you.
So the timing is as follows. The Act, the 1978 State Immunity Act, achieved royal assent on the 20th of July, 1978. The amendment by the Rules Committee to bring in the ex parte procedure was made on the 24th of July, 1978. So 4 days later. Order 73 Rule 10 bringing in the ex parte procedure came into force on the 1st of September 1978. And then the 1978 Act commenced on the 22nd of November 1978.
Sorry, what's the date again?
The Act commenced on the 22nd of November 1978.
Thank you.
So we accept that that means that the rules were made 4 days after royal assent for the 1978 Act. However, in view of the fact that the Lord Chancellor, Lord Elwyn Jones, led the Rules Committee at the time and was the principal government sponsor of the 1978 Act, we submit that Parliament is likely to have been aware of the impending rule change. And in any event, it is undoubtedly the case that Parliament can be taken to have known of the ex parte procedures that were already in place for registration of foreign judgments, as I've shown you, and which already applied to arbitral awards that met the conditions in Order 73, Rule 8. Parliament must be taken to have appreciated that similar arrangements would be likely as regards enforcement of other categories of arbitral awards, particularly in light of the recent ratification of the New York Convention. Now, Parliament's concern to provide...
Mr. Toledano, my Lord Briggs has a question for you.
Just a short one. You dealt with foreign arbitration awards. What was the position in 1978 in relation to domestic arbitration?
So my Lord, they were also covered by this new Order 73 Rule 10.
Yes, but prior to that, what was the position in relation to domestic ones?
Prior to that, you could obtain leave to enforce them under the statutory mechanism, but it wasn't an ex parte procedure until it became an ex parte procedure by the new rules that came in on the 1st of September 1978.
Right. Thank you.
I was then going to turn, if I may, to how one can see Parliament's concern for the policy of speedy and effective enforcement of arbitral awards in the context of the 1978 Act. And that emerges from the Court of Appeal decision I mentioned earlier in the Svenska case, which you should have in the authorities at page 680. It's in the second authorities bundle. Now, in this case, the Court of Appeal concluded that an application to enforce a New York Convention award under Section 101 of the 1996 Arbitration Act fell within Section 9 of the 1978 State Immunity Act because it related to arbitration within the meaning of that section. And if you'd be kind enough to look at page 719, in paragraph 117 of the Court of Appeal's judgment, 5 lines down, the Court of Appeal said, arbitration is a consensual procedure. The principle underlying Section 9 is that if a state has agreed to submit to arbitration, it has rendered itself amenable to such process as may be necessary to render the arbitration effective. And then dropping down a few lines, the Act itself draws a distinction between proceedings which relate to the arbitration, Section 9, and process in respect of property for the enforcement of an award, Section 13. In our view, an application under Section 101 of the Arbitration Act 1996 for in leave to enforce an award as a judgment is, as subsection 1 recognises, one aspect of its recognition, and as such is the final stage in rendering the arbitral procedure effective. And enforcement by execution on property belonging to the state is another matter, as Section 13 makes clear. And so if you then look at paragraph 109, my Lord Briggs, we can't hear you, I'm sorry.
I misheard your paragraph number for that judgment.
I'm so sorry, my Lord. It's paragraph 117.
Thank you.
And that's really making the point that I'd made already about this being this type of application being the final step in rendering the award effective, and is part of the adjudicative jurisdiction, and it's something separate to execution against property, which is dealt with separately in Section 13 of the 1978 Act. And then if you'd be kind enough to look at paragraph 119, what the Court of Appeal does is describe the parliamentary debates relating to the 1978 Act. The Lord Chancellor, who I've already mentioned in the context of the Rules Committee, Lord Elwyn Jones, he referred in Parliament to the fact that enforcement of arbitral awards had been initially excluded from the scope of Section 9, from the scope of the Section 9 exception to state immunity, but the exception was broadened so as to include applications for permission to enforce arbitral awards, for which there is therefore no immunity. And then in paragraph 120, the Lord Chancellor had also made it clear that Section 9, that the exception was to apply not just to awards made within the territory of the UK, but to foreign arbitral awards as well. And then in paragraph 121 at letter G, the Court of Appeal concluded that Section 9 was not ambiguous on these points, but that even if it was, the two statements of the Lord Chancellor put the matter beyond any doubt. And then if you'd be kind enough to look over the page at paragraph 122 at letter B, the Court of Appeal points out that the 1978 Act was enacted to give effect to the European Convention, but departed from it in certain respects, which is a point I've already made, particularly in Section 9. The European Convention in Article 12, much like the later UN Convention, didn't remove immunity for applications to enforce awards, but it's clear that Section 9 of the 1978 Act went further and did so, no doubt as a result of the significance that Parliament attached to rendering the arbitration procedure effective. So that's the important decision of Svenska. Can I now invite your attention, please, to the new Order 73 Rule 10, which is at page 38 of the authorities bundle.
Sorry, page?
38 of the first authorities bundle. It came in as paragraph 4 of the Rules of Supreme Court Amendment number 4, 1978. So if you look at paragraph 4, which should be at page 40, can I ask you please to note the key features? Under subparagraph 1, it provides for an application for leave, which may be made ex parte, but the court can direct that a summons be issued. Under subparagraph 2, even where the court directs that a summons be issued, it is one to which no appearance need be entered. Under subparagraph 4, it is the order which must be served on the debtor, and under subparagraph 6, the debtor may apply to set aside the order. Now, in my submission, at every point, the procedure departs from the terms of Section 12. Where the application is made ex parte, there's no writ or other similar originating document as described in Section 12(1). Even where a summons is directed, no entry of appearance is needed, even though that is the very term used in Sections 12(2) and 12(4). and there is no judgment in default of appearance, which is the term used in sections 12.4 and 5. There couldn't be a judgment in default of appearance because there's no requirement for appearance and no possibility of default. Instead, there is the different process of applying to set aside the order. Now, we submit that set in its proper historical context, it is plain that the ex parte procedure was intended to fall outside of Section 12. And it is telling, we submit, that Libya has not been able to point to anything in the legislative history or parliamentary materials to suggest that Parliament intended that all proceedings against states, including by way of ex parte procedures, would fall within Section 12. So can I just sum up then, because I recognise I've taken this quite fast, but can I sum up on the contextual points that I've been making? We say, in summary, there were the following important features of the background to the 1978 Act. First, that the UK had very recently ratified the New York Convention. Secondly, domestic law in the UK had introduced procedures to enforce awards covered by the New York Convention through combination.
Can you start the second point again, please?
Of course. Domestic law in the United Kingdom had introduced procedures to enforce awards covered by the New York Convention through a combination of the Arbitration Act 1975 and the new Order 73 Rule 10, which adopted the ex parte procedure, which itself was already in use for enforcement of some foreign judgments and which had already been applied to arbitral awards which met the conditions set out in Order 73 Rule 8. Thirdly, Parliament had decided that foreign states were not to be immune from enforcement of arbitral awards, including foreign arbitral awards. Now, against that background, we submit that Parliament would have chosen very different language in Section 12.1 had it intended to capture ex parte procedures for registration of foreign judgments or for enforcement of arbitral awards. And this account of the history leading to the 1978 Act is important, not only because it supplies the context, but because it does demonstrate in my submission how significant Parliament considered the speedy enforcement of awards to be, including as against foreign states. And we submit it's most unlikely that on the one hand, Parliament intended to promote the public policy of enforcing arbitral awards against states, but yet at the same time insisted in every case, no matter how exceptional, that there be a single inflexible procedure for effecting service. It would be wholly inconsistent with parliamentary intention to allow Section 12 of the Act to defeat an application for permission to enforce. And the Court will, of course, bear in mind that a state which has agreed to arbitrate in a contracting state of the New York Convention knows that the procedure it has chosen will lead to an award which is intended to be readily enforceable around the world with a restrictive regime for challenges to an award. That was indeed the very purpose of the New York Convention. By the time the award comes to be enforced, the state in question will have had the opportunity to participate in the arbitration and will be on notice as to the content of the award rendered against it. Now, of course, even if the ex parte procedure is used and Section 12 is therefore not engaged, the rules of court still provide that the order should be served on the state, which will therefore be given an opportunity to set it aside. And in all but exceptional cases, service of the order will be under 6.44 of the CPR, which does provide for diplomatic service. But 6.44 of the CPR, like all the other service provisions in the CPR, is subject to the rules providing for alternative service and dispensing with service in exceptional circumstances. Now, Libya suggests that this might result in a state's assets being enforced against without the state being served. And there are 4 points I would make in response to that. First of all, service would only be dispensed with in exceptional circumstances. So in most cases, the concern would not arise at all. Secondly, in all the recent cases, it has either been clear that the state is already fully aware of the proceedings, or the ex parte order has required the state to be put on notice by other means. And you've already seen the order of Tier J doing that in the present case. Thirdly, the procedures which exist for executing a judgment against assets are subject to their own procedural regimes. Those regimes have safeguards in place to ensure that a judgment debtor and any third parties with interests in the property are given a proper opportunity to be heard before the assets are realised. Precisely when documents need to be served under those regimes or other notifications given depends on the details of the regimes in question. However, if the document in question doesn't institute proceedings, then of course Section 12 will not apply and service can occur through alternative routes. The fourth point I would make is that the protections which I've just mentioned are sufficient for all other litigants. And it's not obvious at all in my submission that a state needs any further protections, especially in exceptional cases, and bearing in mind that even in those exceptional cases, it will be given notification and an opportunity to assert its immunity if it wants to do so, as indeed Libya has been given in the present case. Now, I accept, of course, that being put on notice is not the same as formal service. That said, this court, in both Abella against Badarani and Barton against Wright Hassel, stated that the most important purpose of service was to ensure that the contents of the documents are brought to the attention of the person served. And that purpose can, in exceptional cases, be satisfied by other appropriate means. The other purpose of service identified in those Supreme Court authorities is that you need a definitive moment in time from which to measure time periods, such as those for acknowledgement of service. However, when you dispense with service on terms, whether for a state or for an ordinary litigant, you achieve that certainty by the terms of the order, which will identify a precise date from which time should start running and any time for the defendant to respond. Now, at this point, may I please deal with 3 points relied on by Libya. First of all, Libya relies on what my learned friend described as other contextual features. We say that none of those contextual features advanced help its case. And that's because they all beg the question for the court as to what is the meaning and scope of Section 12 in the first place. So they don't actually advance the debate in my submission. Second of all, Libya says the effect of our construction is to leave issues of state immunity to the discretion of municipal courts. And there is, we say, a short answer to that. Issues of substantive state immunity are matters of law, not discretion. But here we're talking about issues of procedure, which are clearly matters for the municipal court and ought to be subject to discretion, at least in exceptional cases. The third point Libya relies on is that the executive branch should have primacy in the realm of international relations, and the judiciary should permit the executive to exercise that primacy. That's in their written case at paragraph 1.9. And they effectively say that if the FCDO decides for whatever reason that it doesn't want to use the diplomatic channel against a particular state, even perhaps for an indefinite period of time, then that decision should not be second-guessed, and the claimant would have to be denied access to the court to press its claim. Now, we submit that is a very dangerous sounding proposition, which flies in the face of a claimant's Article 6 rights, to which I will return, and which is also inconsistent with the very essence of the restrictive theory of immunity which underpins the Act and which I've already dealt with. And we do pray in aid.
Mr. Toledano, is there any authority that supports the view that the Foreign Office can behave in that way?
We submit not, and indeed, in our written case, we refer to Belhage against Straw, a decision of this court, upholding the decision of your lordship and others in the Court of Appeal in that case. When analysing different types of foreign act of state in that case, Lord Mance, at paragraph 41 of the judgment, referred to a further doctrine which was argued for by one of the parties, said to preclude the UK courts from investigating acts of a foreign state if the Foreign Office communicated the government's view that investigation would embarrass the UK in its international relations. And Lord Mance said he saw no attraction, I think he said little attraction in, and no basis for giving the government so blanket a power over court proceedings. He accepted that there might be consequences for justiciability, but he clearly was uncomfortable about the width of that proposition. Lord Neuberger, at paragraph 149 of that judgment, took a similarly dim view of the suggestion that the executive should be able to dictate to the judiciary in this way. So
yes, but he did then go on to leave open, in that same paragraph, he did go on to leave open the possibility that that could be a matter which a conclusion that the court could arrive at itself, as opposed to being dictated to by the executive. So the point was left open, and Lord Neuberger's speech, I think, commanded the support of the majority.
But
so that point's left open.
But I accept that, my lord. But clearly, those two judgments express some concern about the width of the sort of proposition that Libya is putting forward. Yes. And we submit that judicial review is no answer at all, because it just simply wouldn't work. I mean, in many cases, it wouldn't be a case of the FCO saying, "Well, I'm just not going to do it," and then you could judicially review that. It would be the FCO saying, "I can't do it. The circumstances are too dangerous," or the state in question has a policy of not accepting documents through the diplomatic channel, or one of those sorts of reasons. And in those cases, judicial review wouldn't help, because it wouldn't be an irrational decision. It would simply be, it may be a rational decision. That wouldn't supply the answer if ultimately what you're left with is an indefinite period of time in which they say that they're not going to be able to serve, or they're not going to try to be able to serve, or they can't. And that would, in the end, be inimical to Article 6 rights of access to the court. And the sort of delays that would be produced, even if it was ultimately possible, the sort of delays that would be produced would itself infringe Article 6 rights. So that is no answer at all in these sorts of exceptional cases that the court is being presented with. My lord, can I deal with the authorities then? And I'll try to deal with them as briefly as I can, just in view of the time. And I won't ask you to turn them up, but I'll summarize the main points that we extract from them. Of course, all the references are in our written case. Can I start, please, if I may, with the decision of the High Court of Australia in the Firebird against Nauru case, which, for your note, is at page 898 of the authorities bundle. Now, we say that decision of the High Court by a 4-1 majority does support our case that ex parte procedures are different in kind and therefore fall outside of Section 12. Now, in very brief summary, Firebird had obtained a judgment in Japan in relation to sums owing to it from the Republic of Nauru. Firebird applied to register that judgment ex parte in New South Wales under the Foreign Judgments Act. The registration order was made, as was an order giving permission to serve the registration order on the Secretary of Justice for Nauru. We know from the first instance decision in that case that service was done by a private process server, not via the diplomatic channel. Now, Nauru applied to set aside the registration order, including on the basis that it had not been served by the diplomatic channel, as it said was required. The majority of the court rejected that argument and upheld the registration order. And they did so even though there'd been no service of the originating document, and the order itself had simply been left at the office of the Secretary of Justice in Nauru by this private process server. And the essence of the majority's reasoning was that the statutory provisions requiring diplomatic service only applied when a default judgment was obtained. The registration order was not a default judgment, they said, because no appearance was required and judgment was not given in default of that appearance. And in doing so, they rejected the argument that a state always had to be served with initiating process before a judgment could be given or order made against the state. And we've set out the references in our written case, so I won't go to them now. But we say that case strongly supports the analysis of the Court of Appeal that this court is concerned with. Now, that decision of the High Court of Australia is, we submit, consistent with prior English authority, which has at least implicitly accepted that Section 12.1 does not apply to ex parte proceedings. And the example that we rely on is the well-known decision of Mr. Justice Peter Gibson in Westminster City Council against Iran, which is at page 726 of the authorities bundle. That case concerned the hostage crisis at the Iranian embassy in London. During the SAS operation launched to free the hostages, a fire gutted the building. The council, Westminster Council, incurred costs, making the building safe. They sought to recover those costs from the state of Iran. The council sought to register a charge on the property in question. Now, at the request of the Chief Land Registrar, the council issued an originating summons, but was met with the difficulty of how to serve that summons on the state of Iran. The case came before the court in 1986, at which time there was no general power in the rules of court to dispense with service, because the general power to dispense with service didn't come in until April 1999 with the advent of the CPR. Now, Mr. Justice Peter Gibson held that the court could not therefore rule on the substantive question before the court. He reached that conclusion with no satisfaction, said he found it disquieting that the Iranian government could frustrate the resolution of the court process. And it's clear from his judgment in our submission that if he could have found a way to avoid the need for service, he would have done so. He expressly considered whether it would have been appropriate to use an ex parte originating summons, and clearly thought that such a ex parte summons would have fallen outside of Section 12, but decided that was not the appropriate procedure in the circumstances. He also considered whether he could use certain specific powers in the RSC to dispense with service, but concluded that they didn't apply on the facts. And just one point I would add about that case, at page 727 of the judgment, no need to go there now, at letter H.
Sorry, which page?
727 at letter H. You'll find a reference there to a point my learned friend made about Sweden, how you could ask for another state to intervene to help you to effect service if you couldn't do it yourself. In fact, what you'll see recorded in that judgment is that Sweden refused to assist. And so, if anything, that point is in my favour rather than in my learned friend's favour. But that's where there's a reference to Sweden. So that's the Westminster case. In paragraph 66 of our written case, which is pages 69 to 70 of the key documents bundle, we deal in writing with two other authorities relied on by Libya. One is called Norsk Hydro, which was a decision of Mr. Justice Gross, and the other is the Singapore case that my learned friend referred to this morning, which was Van Zyl and Lesotho, decided by Mr. Justice Ramesh of the Singapore High Court. Now, we've dealt with both in writing. Neither authority has grappled head-on with the arguments raised in the present case, and that, although my learned friend relies heavily on the Singapore case, it simply, the arguments we have presented in this case and that found favour with the Court of Appeal below were not presented in the same way to the court in Singapore. We say, for those reasons and the ones we set out in writing, those authorities do not help my learned friend. The other case relied on by my learned friend is the European Court of Justice in 1995 in Firma Hengst, at page 733 of the authorities bundle, that was the one the court will recall where the ECJ was construing Article 27.2 of the Brussels Convention. We say that doesn't help. What matters in the case today are the words used and the meaning of section 12.1, not how different words were interpreted in a different instrument by the ECJ. The ECJ, of course, was identifying an autonomous interpretation for European legislation in an entirely different and distinct context. In that case, it related to the enforcement of judgments in civil and commercial matters within the EEC against all parties, not specifically against foreign states. And so the context was entirely different. And I would add this, that Article 27.2 of the Brussels Convention didn't even use the same language as that which was later used in the European Convention on State Immunity. And the language in the European Convention on State Immunity was not replicated by the 1978 Act. So you actually have, it really does stretch things beyond breaking point to rely on the 1968 Brussels Convention, which used different language to the 1972 European Convention on State Immunity, which in turn wasn't adopted and was departed from in the 1978 Act. So we say that doesn't go anywhere. And those are the submissions I wanted to make on our primary case. I can move on then to our second construction, the alternative case, which we advance, which we submit provides another route by which the court should conclude that the ex parte order in the present case fell outside of section 12.1. Now, this second route focuses on the fact that section 12.1 only applies to documents that are required to be served. And we say that in order to ascertain whether a document is required to be served, it is necessary to consider all the rules of court, including those which give a power to the court either to require service or to dispense with it, and to consider the issue at the point in time after the court has exercised that power or declined to do so. And we say there's no logic in approaching the words required to be served in any other way. So by way of example, your lordships and your ladyship will recall that CPR 62.18.1 in our context provides that an application for permission to enforce an award may be made ex parte, but subparagraph 2 gives the court a power to direct that the claim form be served. If the court did so direct that the claim form be served, then the claim form becomes one that is required to be served, and it would fall within section 12. Similarly, 62.18.7 provides that an ex parte order must be served, but CPR 6.16 and 6.28 give the court a power to dispense with service. If the court does dispense, then the document is not one that is required to be served and cannot fall within section 12, even if it otherwise would, which of course we say it wouldn't, because it wouldn't be for instituting proceedings. That's the point I've already addressed. Now, if this analysis that I make now is correct, then it would apply to any and all proceedings against states and not just to those covered by the ex parte procedure. It's therefore one way that this court can resolve the problem thrown up by several recent authorities where states have shown a willingness to evade service by the diplomatic channel. The construction that we advance would ensure that the procedure identified in section 12 is not allowed to deprive claimants of recourse to the court's adjudicative jurisdiction as regards acts of a non-sovereign nature. It's therefore a construction that promotes the policy objective underpinning the Act, which, as I've said, was to give effect to the restrictive theory of immunity. There is nothing in the legislative history of the Act which suggests that Parliament contemplated and was prepared to accept that serving proceedings in accordance with 12.1 might be impossible or prohibitively difficult, such that proceedings would be frustrated. Nothing at all to suggest Parliament understood and was willing to accept that proposition. Now, The Court of Appeal rejected this alternative argument in two paragraphs, 62 and 63 of its judgment, with very little analysis with respect to the Court of Appeal, possibly because they'd already held for General Dynamics on our primary case. But I do want to say a little bit more about the steps in the argument, if I may. Now, the starting point, which in a sense I've already made, is that whether a document is required to be served has to be answered by reference to the civil procedure rules. So much ought to be uncontroversial. It's those rules which provide whether any document in civil proceedings is required to be served. And the whole focus of Section 12 is on those rules, as I've already said. Now, we submit that must mean the procedural rules as they exist today. It cannot mean as they stood frozen in time in 1978. And the principle of statutory construction we rely on, which I mentioned briefly earlier, is set out in 74A of our written case at page 71 of the key documents bundle, which is the legislation referentially point, where you've legislated by reference to something else, here by reference to the civil procedure rules. Where Parliament does that, you would expect it to be ambulatory and to look at the rules as they change over time. And we point out in our written case at paragraph 75, which is at page 72, that the general power to dispense with service of claim forms and other documents was only introduced in 1999 by the CPR. But it's important to appreciate that it wasn't an entirely new innovation at that time. There was no general power to dispense with service prior to 1999, but dispensing with service in particular instances is well established. And we've cited three examples which existed prior to 1978 in our written case. First, the power to dispense with personal service of an order as a precursor to committal or sequestration, which from at least 1966 had featured in the RSC as Order 45, Rule 7.7. And that's, as I say, this is all in our written case. Secondly, a power to dispense with originating process in matrimonial proceedings. And thirdly, a power which existed between 1942 and 1963 to dispense with service of a writ on an enemy if prompt personal service was impossible or could not be proved. My Lord, Lord Stevens.
When Parliament passed the 1978 Act, it assumed that writs would be served through the diplomatic channel. And the difficulty I have is how to have an intention that the Rules Committee could change all that. Not the legislature, but the Rules Committee could change all that. So there's a statutory provision which is understood as requiring service through the diplomatic channel of a writ, and yet the Rules Committee could just wade in and make the alterations to it.
Well, the answer to that, my Lord, is really the one I was giving, which is that even as at 1978, it wasn't the case that all originating documents like writs in all cases had to be served. As I say, I've dealt with the ex parte procedure, but even leaving that aside, there were these specific instances where even in 1978, a court could dispense with service of an originating document. And so what we say is that the fact that those sorts of situations already existed means that Parliament must have known that it must have been within its contemplation that such processes for either not providing for service or dispensing with service might be extended by the rules over time. In other words, it wasn't an entirely new innovation when it came in 1999. It reflected the fact that there had already been instances of this for a long time, well before the 1978 Act. My Lord, Lord Briggs.
Mr. Doyle, correct me if I'm wrong, but prior to the arrival of the CPR on the scene, was there not quite a quite a general power in under the old RSC to permit a party to serve by an alternative method, where the method of service prescribed by the rules ran into difficulty.
Yes, I think that's right. For alternative service, that already existed in the RSC, but not for dispensing with service.
No, but it was an alternative way, as it were, by way of departure from what used under the RSC to be pretty limited and strict rules about service.
Yes, that's correct. That was already in the RSC. That's my understanding. Yes.
Yes.
When Section 12 of the Act says that any writ or other document required to be served for instituting proceedings against the state, it's referring there, isn't it, to the general rule applying to the generality of writs and other documents, and you can't look to a specific case, particularly a specific case in which a judge gives permission to depart from the rule in the primary statute.
Well, that's with respect, that's what I'm addressing. We submit that absolutely you can, because because Parliament has legislated by reference to the rules, and has said you only have to go through 12.1 if it's a document that meets the test of required to be served for instituting proceedings. You then have to consult the rules to see whether or not it is one of those documents or it's not. And if the rules, as I said before, if the rules sometimes permit you not to serve and other times require you to serve, then you have to look at the rules and see what they say. As I say, some of the rules have a default position, but other rules allow the court either to require service or to dispense with service. And it's in my submission, it would be very strange if Parliament was effectively saying, well, you have to close your mind to those rules which allow the court to step in and either require service or dispense with service, and only look at the rules that have a default answer.
Court has power to dispense. Sorry. Focusing with those cases where the court has power to dispense with service, then it would be very odd, would it not, if Parliament had laid down a rule which was to be capable of disapplication by a judge. It says any writ or other documents required to be served, referring to the generality of the normal situation.
Well, in the way that we contend, it's not a judge disapplying the statute. The statute only applies if the statutory test is met, and whether the statutory test is met requires regard to be had to the rules, and the rules in turn, in some cases, require you to see whether the court does or doesn't require service or dispense with service. And so it is actually what the legislation has provided for, rather than the court coming along and disapplying the statute. It's the other way around. It's giving meaning to the statute because Parliament has chosen to legislate in this particular way by reference to the rules.
If it's applying in the generality of cases, it can't mean required by a judge in a particular case to be served.
Absolutely. It means required by the rules of court, all of the rules of court, including those which set a default position and those which give power to the court in a particular case either to order service or dispense with service. So you're absolutely right that the statute is doing no more than saying you must consult the rules, and that's very clear from all the other subsections as well, which refer to the rules. Sometimes the rules do require you to have a regard to what the court does or doesn't do in a particular case, and we say you can't draw the line, if you like, between the default rules which say, well, yes, ordinarily you have to serve a writ, and other rules which say you don't have to, or in a particular case you don't have to.
But it is important, isn't it, that it doesn't say required by the rules from time to time. It means required by any principle of law or rule to be served for instituting proceedings. Otherwise, it would have said by the rules of court or whatever. It doesn't say that. You can look for any source of law for your requirement.
Well, with respect, the source of law very clearly identified in Section 12, as I say, the rules of court are referred to themselves 3 times in section 12, and
But
lots
not in
and lots of
12.1.
terms of art are used in section 12.
Right, but not in 12.1.
The rules of court are not themselves referred to in 12.1, but terms of art from the rules of court are used in section 12.1, and 12.1 is meant to, go together with 2 and sub 2 and sub 4, which do refer to the rules of court. So we say when you look at the whole of the section, it is clear that what's being identified here is the rules of domestic procedure, nor is that at all surprising, because that's what you'd expect this to be legislating by reference to. It's not, if you like, a strained or surprising construction. So we do submit that our case is a strong one for an ambulatory interpretation. I know that this court considered very recently a similar point in the Franked Investment Income Group litigation, which looked at a similar question. But we say our position is much stronger because of the way that the statute is drafted. It's not a question of can you take into account a later development that wasn't known to Parliament at the time of the Act. Here, Parliament has required you to have regard to the rules, which everybody knows change from time to time. And anyway, the innovation in 1999, as I've already said, was not really an innovation at all. It was something that very much followed on from the type of processes that were already in play in 1978. And then we say that Libya's concern about this taking away procedural protections is not a point that need concern you, because of the points I've already made, that this would only apply in exceptional circumstances and protections could be built into the order, as indeed happened in this case. In relation to my learned friend's reliance on the Kuwait Airways case, can I just say these points about that case? That was not a case concerned with the ex parte process for enforcement of arbitral awards, so it doesn't deal with that point. It was pre the general power in the CPR to dispense with service, because it was in 1995, the power came in 1999. It was pre the Human Rights Act, which came in 1998, and none of the arguments that the court is concerned with today were raised in that case. The only point that was decided on service was whether good service could be affected by service on the Iraqi embassy in London, and that was rejected. Nothing else about service was argued or decided. Can I move on then, if I may, in the short time remaining, to the third argument that we make, which concerns rights of access to the court. Now, we submit that Libya's construction, if correct, would prevent access to the court and infringe our constitutional and Article 6 rights. And it is clear from the authorities that procedural barriers and indeterminate and unreasonable delay to the adjudication of claimants' rights are sufficient to engage Article 6. And my learned friend relied on the fact that we hadn't sought a declaration of incompatibility, but that's because we say that the practical solution in this case is not a declaration of incompatibility, but the practical solution to what would otherwise be an infringement of our Article 6 rights is through giving an interpretation under Section 3 of the Act that is compatible with our rights of access to the court under Article 6. And as the court knows, the court can go very far under Section 3, provided that the construction is not incompatible with a fundamental feature of the legislation, which we say it's not in this case.
But in many cases, if I may just ask, in many cases, there won't be delay. If there is excessive delay and there is a problem with Article 6, it is a question of a violation, not a question of the rule being wrong, surely.
Well, if Libya's construction is correct, then on its case, there is no other way of getting the proceedings started. You cannot serve, you cannot proceed with enforcement of your arbitration award, you cannot get in front of the court at all. So that would be an infringement of our rights. We've already waited, as the court knows, a very long time indeed.
But the evidence is, as I understand it, is that there will be delay in service. And I can understand that during a period from the decision of the Court of Appeal, nobody has really been pressing the question of service in Tripoli. But if the position is that there can be service, it will just take a bit of time, because we need to, the Foreign Office needs to find a time when there will be a diplomat admitted to the ministry. Then it is a delay question, not a question of the rule being incompatible. It doesn't destroy the right of access to court, it merely delays it. I appreciate delay is important.
Absolutely. So I'd make 2 points. First of all, delay is important, and unreasonable and indeterminate delay does infringe rights of access under Article 6, as the authorities make clear. We say the delay in this case is already unreasonable, and the findings of the courts below show that it is indeterminate. We simply don't know how long it will be, if it will ever be possible at all, which is referred to in all of the judgments below. The second point I'd make is that the court obviously has to come up with a construction that works in all cases, including in those cases where it's not just a question of delay, where if Libya's right, but the state in question is simply going to obstruct service always by the diplomatic channel, then there would be no way of getting access to the court at all. And so we say you do have to adopt a construction like the construction that was adopted by this court in Pomichovsky and Poland, which we give as an example, where the court said, well, okay, the statute has given absolute time limits for appeals to be brought, but that would actually create unfairness. And so it has to be read under Section 3 in a way to carve out for exceptional cases. And we say that the same ought to apply here. And the analysis in that case, Lord Mance saying that Parliament had not accepted this kind of situation would occur where there'd be injustice that would result from a contrary construction. We say that very much applies in the present case as well. And on the assumption there's no rule of customary international law, which I'll come on to in a moment, then of course Article 6 is engaged. We say that the construction Libya advances does impair the very essence of our right of access. It doesn't pursue a legitimate objective, and it's not proportionate. And it's not proportionate because if there was a carve-out just for exceptional cases of this kind, you would still be able to pursue the objective of service by the diplomatic channel in most cases, but you would at least allow the possibility that in this type of case, where you otherwise have this indeterminate delay, you would be able to access the court to enforce your arbitral award as you ought to be entitled to. And states cannot have a legitimate expectation of always getting service via the diplomatic channels. For the reasons I've already identified, there are limits on that circumstance. The other point I want to just address very quickly is my learned friend says, well, under 12.6 of the statute, we could have agreed a specific method of service with the state in question. That doesn't help him because we didn't, and there isn't a method of service that's been agreed. And the right of access to the court can be impaired even in individual cases, as Lord Mance said in the Pomichovsky case. So it's not enough to say, well, in other cases, you could have a bespoke method of service agreed. And indeed, I would go further and say in many cases, you won't be in a position to agree something like that with the state. And indeed, in lots of cases against the states, such as the Westminster against Iran case that I mentioned, it's not a case that results from an instrument that you've agreed with the state at all. So you're not in a position to agree something with the state. So that point doesn't assist my learned friend. Very briefly, can I just deal then with customary international law?
Forgive me, Mr. Toledano, before you move on to that, let's assume for a moment that you're right on customary international law, and there's no rule of customary international law requiring service of initiating proceedings to be effected through diplomatic channels. But there's an alternative way in which it's put, and that is that it is a widely established practice, and that many states take the view that this is an appropriate way of doing it, and that there is therefore a principle of comity, that it may be, and states are entitled to take the view that it should be done in this way, even if it falls short of a rule of law. Now, if that's right, then if you look at what the Strasbourg court said in Al-Adzani, that would be accepted as a legitimate objective, wouldn't it?
Well, my lord, not if it produces the result that it deprives litigants of access to the court and infringes Article 6. It wouldn't be a legitimate.
In Al-Adzani, the court took the view that the grant of immunity may or may not be a rule of customary international law. In fact, I think they said it wasn't a rule of customary international law at that stage, embassy diplomatic disputes, embassy employment disputes. But nevertheless, they said, even though it falls short of being a rule of international law, it could still be a legitimate objective, even though it prevented people suing.
Well, even if it could be a legitimate objective, it wouldn't be proportionate to have an inflexible rule of that kind that could prevent access to the court. And it would impair the very essence of the right in the cases where you therefore couldn't get access to the court. So even if, on your lordship's hypothesis, it could satisfy one of the tests for this, it wouldn't satisfy all of them. The only way Libya could possibly get around Article 6 is customary international law, which is no doubt why, for the first time in this appeal, it argued that there was a rule of customary international law. If it was right about that, that would take away the adjudicative jurisdiction, but it's not right about that. And we say there is no halfway.
You're now going to tell us why it's not right.
My lord, yes, but absolutely, we say there's no halfway house. If they can't establish the rule they set out to establish in their written case, then they don't get anywhere, and Article 6 is engaged. That would be my submission. Now, yes. They touched on it very lightly in my learned friend's submissions, and they seemed, in my respectful submission, to be backing away from it. We say they don't come close to satisfying what your lordship and my Lady Arden described in the Court of Appeal in Benkabush as the stringent requirements for establishing customary international law, and the requirements described by the Supreme Court as well in that case. They don't come close to establishing that test. Now, we have put forward, I mean, it seems to be, my friend said, well, there are lots of states who do it this way. You will have seen that state practice is diverse. In each of the USA, Hong Kong, Australia, Germany, and Switzerland, there is authority which confirms that diplomatic service is not mandatory in every case. Libya only referred to a small sample of states in its analysis, and it wrongly described the High Court of Australia in Firebird, relying only on the dissenting opinion in that case without referring to the majority, which, as I've said, strongly supports our argument. Their case, really, when you look at it in their written case, is based on the UN Convention. And we say that when you approach that convention in the way that the Court of Appeal and the Supreme Court mandated in Benkabush, it's absolutely clear that you have to look at each provision of the UN Convention. You can't just say, well, the UN Convention is an authoritative statement. You have to see in detail whether, in the particular instance relied on, it was legislative or whether it codified customary international law. And we have put forward material that Libya hasn't even addressed in our written case that demonstrates, really beyond any shadow of a doubt, that Article 22 of the UN Convention was legislative. It did not codify customary international law. There were lots of different iterations of the International Law Commission, some of which did have a more flexible process. In the end, a middle ground was adopted. That was the term that was used by the ILC, clearly legislating a middle ground. And it's quite clear that none of that comes close to any suggestion of codification of international law. We've also referred in our annex, and I would obviously ask the court to look very closely at our annex where we've set out, annex to our written case where we've set out all of this in detail. But we do refer to the International Law Association as well, because they produced a convention on state immunity as well as the UN Convention. And that had also very eminent committee members, Lady Fox and Sir Ian Sinclair, who himself had been a member of the ILC. And you'll see that they adopt a convention which has a much more flexible process. And there's no suggestion in any of their drafting history that they thought that there was a rule of customary international law. Lord Wilberforce actually spoke, we set all this out, Lord Wilberforce actually spoke on behalf of the British branch of the ILA and expressed his agreement with a more flexible procedure. And we say that the only authority that my learned friend really has in his favour on this question is the European Court of Human Rights in the Wallis-Hauser against Austria case in 2012. We've answered that in paragraph 25 of our annex now, and this court shouldn't place any weight on the statement in that case for the reasons that we've said. We've also, in our annex, set out the decisions from Hong Kong, Australia, and the US, where it's quite clear that you don't always have to have diplomatic service. And many of those authorities do emphasize that the reason for that is that if you don't have some alternative, then process will be frustrated. And that's simply not what is permitted in those states in question. So for those reasons, we urge the court to reject the rule of custom international law. Without it, we submit that we have a strong argument under Article 6 of the Convention, which should be given effect to by a construction under Section 3 of the Act. And those are the submissions for the respondent, unless I can assist the court.
Don't think there are any questions, Mr. Toledano. Thank you very much. Mr. Matto.
My lord, my lords, my lady, I hope you can hear me. I can't tell whether
Yes.
I'm on mute. Thank you. My lord, dealing with my learned friend's primary case on the interpretation of Section 12.1, we say that it is clearly intended to be applied widely, and it can be applied to orders to enforce arbitration awards, because they are documents instituting proceedings in the sense which I described in my opening, and they have to be served pursuant to CPR 62.187. They amply meet that requirement. My learned friend says, well, Libya has to say that a defendant in the position of this state here, which then has an opportunity to apply to set aside such an order, cannot be said to be entering an appearance for the purpose of Section 12.2 and 12.4. We disagree. And if the court looks at Section 22 of the State Immunity Act, that's in the primary authorities bundles at page 20, or is it 19? Might be worth just turning that up, if I may respectfully ask the court to do that. Section 22.2 says that in this act, references to entry of appearance and judgment in default of appearance include references to any corresponding procedures. And so we say that in the context of an order to enforce an arbitration award, which is the document which brings a state, in this case, before, or seeks to bring a state before the municipal court, entry of appearance is the process by which a state either accepts that jurisdiction or challenges it by seeking to set aside the order. It corresponds with an entry of appearance in the case of a standard writ. And so, my lord, my lady, in those circumstances, Section 12.1 is amply capable of accommodating this sort of procedure. And the procedure is said by my learned friend to be equivalent to other applications where ex parte processes are used. And in his submission, therefore, it falls without the regime for issue and service of writs, for example. And when he introduced this aspect of his submissions, he said that he was going to talk about the enforcement of foreign judgments and awards. And then he said that applications to register foreign judgments can be made ex parte. And your lordships and your ladyship will see that there is an elision in that submission between applications to enforce on the one hand and applications to register judgments on the other. An application to register a judgment is a very different creature indeed. An application to register a judgment is simply an application in effect to domesticate a foreign judgment or to bring an arbitration award into the to give it the imprimatur of the court's authority, so that if a claimant thereafter wishes to enforce that registered judgment against anyone whomever it chooses, at that stage it would have to serve the targeted person with the process in question. So registration of a judgment in order either to domesticate it if it's a foreign award or to give it the imprimatur of the court if it's an arbitration award is a very different beast from an application to enforce. And one sees that in the Firebird case, beloved of my learned friend, where at paragraph 213 in the judgment of Justices Nettle and Gordon, which he urges upon the court, your lordships and your ladyship will see their lordships in that case making it clear that a registration of a judgment is, as it were, an action in rem, which becomes an action in personam when you seek to take action upon it against a targeted defendant. And so we say what you need to look at is ex parte applications which are in personam. Now, such applications in our submission are classically applications to enforce. And if my learned friend is right in his submissions, any application to conduct enforcement process, any of the typical applications to conduct enforcement process, would fall outside the ambit of section 12.1 when the targeted defendant is a state. Charging orders have ex parte applications followed by applications to set aside. Garnishee orders, as we used to call them, now third-party debt orders, are the same. Those classic examples of enforcement, if you wish to go against a state, on my learned friend's argument, allow a court to dispense with service in accordance with 12.1, such that it may be that the state never receives proper notice of your intention to take a bank account, which might be set aside for the payment of interest on a huge bond issue, or to charge valuable real estate, which is in the process of being disposed of by the state. And you can do that without giving the state the privilege of the procedural protections which section 12.1 allows. We submit that that is not a correct or realistic reading of section 12.1. My learned friend referred the court to the Westminster City Council case and to the anxieties of Mr. Justice Peter Gibson as to how it might appear that the Iranian government in that case was able to get away with the attempts at enforcement against it by way of a charging order that the claimant sought. But in our respectful submission, cases such as Westminster City Council and other cases which my learned friend relied on could be readily dealt with by the court deciding that a recalcitrant state defendant seeking to frustrate the jurisdiction of the court cannot do so if and once process has been, quotes, received, close quotes, by it. and the court has heard my submissions as to the meaning of receipt. It doesn't necessarily mean voluntary receipt. And if Mr. Justice Peter Gibson in the Westminster case had said, well, if the Iranian embassy has taken into its hands or has had put into its possession the charging order in question, even if it throws it back in the face of the process server, it has received it for the purpose of Section 12.1. And so Section 12.1 allows justice to be done even in cases where the state is unwilling, obstructive, recalcitrant, and in defiance of its obligations under international law. So, my Lord, the next point concerns actions in rem, to which my learned friend referred the court. An action in rem is a form of impleader, and in relation to the typical way used to be that it was affected by service of the process document on the mast of the ship. My learned friend says there are different ways of doing that. I bow to his admiralty knowledge on that. But in any event, it is an indirect impleader of the targeted natural defendant, or perhaps here a state defendant. He says it's also a direct impleader. But in any event, the important point is that an action in rem is expressly dealt with in Section 12.7 of the Act. So Parliament, no doubt for reasons which my Lord Lloyd-Jones adumbrated, the need for speed when you're dealing with an action in rem, Parliament expressly excluded actions in rem from the purview of Section 12.1. Parliament could have expressly excluded ex parte applications to enforce judgments or awards, charging orders, third-party debt orders, orders to enforce arbitration awards, but it did not. On the basis of the old maxim of expressio unius, the court could come to the conclusion that if it's only actions in rem and counterclaims which are excluded expressly under Section 12.7, there's no reason to assume that charging orders and orders to enforce arbitration awards do not fall and were not intended to fall within the ambit of Section 12.1. We say there's a very easy construction and interpretation which allows the court to include them in Section 12.1, and that's entirely in accordance with the policy which we've identified to the court for actions against service of claims against a state. Svenska Petroleum was a case referred to by my learned friend, where the Court of Appeal said that an agreement to arbitrate implied an equivalent agreement to enforcement proceedings. Now, I don't want to spend any time more than a couple of sentences on this. I simply refer the court to the Van Gil judgment at paragraphs 38 to 41 on this point. If the Court of Appeal were right that an agreement to arbitrate, which is at the identifies the adjudicative stage of the proceedings and identifies usually the seat of an arbitration for supervisory jurisdiction of the adjudicative stage, has been agreed by a state, it's very difficult to see, in my respectful submission, why the state should also be taken to have agreed to enforcement in any jurisdiction, including the jurisdiction of the seat. But the court already has my submissions as to how difficult it is to identify where enforcement might take place around the globe. We submit that the logic of the Svenska Petroleum case on that point is difficult to follow, and the court may wish to review whether the Court of Appeal was right on that point. But all the cases which my learned friend has put before your lordships and your ladyship regarding ex parte process, the case of Order 73, Rule 10, the precursors, the historical precursors to the current regime, none of them applied to actions against states. None of them addressed this Section 12 point. And the Section 12 point, when one looks to see what the history of the rules of court were and what the position of the rules of court dictated by the current rules of court are, the rules of court on this matter are set out in CPR 6.44, which is very clear in requiring any claim form or any other document to be served in accordance with Section 12 processes through diplomatic channels. And so, my lords, my lady, I should just mention one more point on the Westminster City Council case in relation to my learned friend's excursus on the historical context in which the 78 Act was promulgated. If that Westminster City Council case and the anxieties of Mr. Justice Peter Gibson show that it was impossible, or that that learned judge found it impossible to sidestep Section 12 in Iran's case, because no general power to dispense with it existed when he heard that case in 1986, it is not easy in our respectful submission to conclude that the legislative history and the court rules in 1978, when the Act came into force, establish that Section 12 did not apply in similar cases. My lords, my lady, I then move on to my learned friend's alternative case, where he referred to the ambulatory rule of interpretation, and he gave three examples. One of claims where you could dispense with personal service in contempt proceedings, claims where the court could dispense with service in a matrimonial case, and a claim where the court could dispense with service of suit against an enemy. All very interesting, none concerning claims against a state. Nor does my learned friend, in his discussion of his alternative case and the ambulatory construction, take cognizance of the fact that in today's age we are dealing with the CPR, the breadth of which gives a massive discretion to judges, as I mentioned in my opening submissions. A procedural code, which when it was introduced, as we all know, created what Lord Woolf described as a new landscape for procedure. A landscape which wouldn't have been before the legislators in 1978. The CPR was perceived to be and intended to be revolutionary. And so we come to the Article 6 point, which is a Section 3 point now, and we say three things on that. The Foreign Office, first of all, whether the Foreign Office would have the discretion as to service, something on which there's been considerable debate in this hearing today. My Lord Lloyd-Jones asked my learned friend whether there were any cases which established that the Foreign Office had a broad discretion as to the service of process once it had been asked to achieve it by the Foreign Process Service Department in the Royal Courts of Justice. I couldn't identify any such cases, but I am sanguine about that, because the reason why there are no such cases is because the Foreign Office does its best to effect service. It complies with the expectations that are always put on the executive in the conduct of their relations, both domestically and internationally. And it complies with the expectation inherent in Section 12 of the State Immunity Act, the expectation of the legislature that the Foreign Office will do this without any difficulty in terms of the Foreign Office's attitude to seeking to do it. And so we say that the fact that there are no cases as regards the discretion are rather supportive of our approach. The second point is this, that my learned friend says that delay violates Article 6. It's a small point, this, and he relies on the case in footnote 58, I believe, of his written case, of Palumbo and Italy. But for your lordships and your ladyships note, that case expressly made no finding of delay. The reference is paragraph 48 of the judgment, and that's in the additional authorities bundle at page, or is it tab 54? We'll come up with the specific reference in just a moment. 2267. 2267. Or it may be 2268, for which, yet again, apologies. And then finally, my lord, my lady, we come back to the question of exceptional circumstances and the jury point, which my learned friend started with and which he finishes with, about the unfairness and the injustice of it all, where towards the end of his submissions, he said, we have already been waiting a very long time indeed, and that the delay is unreasonable. My learned friend very fairly took your lordships and your ladyship to the letter that was written in February 2019 by his instructing solicitors, which was the first time that General Dynamics had attempted to serve process in accordance with section 12.1. What your lordships and your ladyship may not have taken on board, because it is not in the papers, is the evidence that was before the courts below as to the history of this matter when it appeared before Mr. Justice Tier. There was evidence which said, and we would be very happy to provide this witness statement evidence to the court in short order hereafter, a witness statement of my learned friend's instructing solicitor of the 21st of June for the hearing before Mr. Justice Tier, saying that he had spoken with the Foreign Process Office in the Royal Courts of Justice on the 5th of June, and they had given a guideline timeframe for service in Libya of over a year, so that there was no certainty of service before 2020. That was in June, and then of 2018, I should say. And then what one sees in paragraph 32 of the witness statement is what Mr. Justice here was being asked. He was asked this, that for the reasons below, there are exceptional circumstances in this instance entitling the claimant to seek permission to dispense with service prospectively. They hadn't even tried Section 12 service. And as to what those exceptional circumstances were which were put before Mr. Justice Tier, that witness statement makes it clear that what was being said was that it was unclear who made up the government of Libya at that time. So that was the basis on which Mr. Justice Tier made his order. And then in front of Lord Justice Males, the evidence put before him by my learned friend's instructing solicitors talked about discussions that had gone on with the Foreign Process Office, and it was said there in that witness statement that it was recognized that it is ultimately for the FCO to effect delivery of court papers into Libya. And so say all of us. And it describes the ministry, the Foreign Office, as explaining that service to the ministry in Libya was not at all straightforward and was not too possible. And the task was too dangerous because the ministry was surrounded by a militia guard. So before Lord Justice Males, the reasons given for upholding the order of Mr. Justice Tier were materially different from those that had been given to Mr. Justice Tier. And then when Libya put in evidence in reply to that, Libya explains the discussions that my instructing solicitors had had with the Foreign Office. And what is said in that evidence is that the Foreign Office said that they would send an advance notice claim, email to the relevant embassy in the relevant state to ascertain whether the situation on the ground was conducive to service, and the consular office in that state, the British consular office, would send back a report to the FCO, and the FCO geographical department, what I believe I called a desk, would then examine the claim documents and whether any sensitive circumstances, such as an election or a visit of the foreign minister of the state, were either pending or existed at the time. And then it would take a decision, A, to transmit the documents to the overseas embassy, consulate, or high commission, or B, to delay the transmission of the documents, or C, to return the documents to the claimant if there's no prospect of affecting service in the short term. And the court may wish to have a look at that evidence. If so, we can make it available to it. But in a nutshell, there is nothing there that suggests that a reading down of section 12.1, as my learned friend seeks to achieve by reliance on section 3 of the Human Rights Act, is demanded in this case, even if he's able to surmount the point made by my Lady Arden, that it would be strange, this is how I understood the point, that it would be strange if the given circumstances of one case could persuade and could entitle a court to construe a statutory provision for all time differently. My Lord, my Lords, my Lady, ultimately, we come back to the point that section 12.1 is a privilege afforded to sovereign states against the normal procedural rules of court. And when my learned friend says, oh, you've got to read section 12 by reference to the procedural rules, well, we would say yes, because it's a privilege against the application of any of those procedural rules. It's a special code for service of defendants who have a special status before municipal courts. My Lords, my Lady, unless I can assist the court any further, those are my submissions in reply.
Thank you very much. Mr. Atavu, Mr. Toledano, the court would be assisted if we could please be provided with an agreed note, can be relatively brief, of the evidence which was before Mr. Justice Tier and Lord Justice Males in relation to the difficulties of effecting service, and the relevant witness statements can be appended to that. We're not asking for a massive submission of documentation. Indeed, we're asking that it should not be. This should be kept to an absolute minimum. We would like these to see what evidence was before the Court of Appeal and was it actually adduced for the purposes of Mr. Justice Tier and Lord Justice Males.
Indeed, my Lord.
No doubt it will take a little time to produce that, but we'd be grateful to receive that in due course.
My Lord,
the court is very grateful to you both for your submissions. We're also very grateful to those who metaphorically sit behind you, normally would sit behind you, but sit just out of camera range, I suspect, in some instances. We're very grateful to you all for the preparation of the case and for the submissions that we've had today. The court will take time to consider its judgment. Court's now adjourned. Thank you very much.